there are certain clauses which you always need to make sure that these clauses should remain a part and parcel of your agreements. These are basically the generic clauses, but without them your agreement contract would not be complete, and you need to make sure as part of your checklist that these clauses are available and well written into your contract, because they will describe many of the dimensions of your agreement. I'm not going into the details of these clauses, but I'm just mentioning them as a heading. First, you need to make sure that you have clearly described the parties and their addresses and their particulars. If they are the company, you need to clearly mention the company details, their tax details, their registration details, their addresses, whatever is as part of their registration into the relevant regulatory bodies with their proper names. Then comes the recitals. For that reason, you need to write the complete purpose and the content of the basic content of this agreement. You need to write different definitions for a few of the terminologies you are using, which needs to get themselves defined into the agreement. And you need to write the terms and the termination. The termination clause is very important, and that needs to be clearly mentioned into the agreement. And then also the scope of work and the obligations for both of the parties. Then you need to write the payment terms. Then you need to write the representations and the warranties. These are basically the promises each party is making into the agreement. You need to write the indemnification clause, and you need to define the liability of the limitation of the liabilities for each of the parties. Then in some cases there is a need to write the confidentiality clause that is called as the NDA, non-disclosure agreement. Then you also need to specify the intellectual property rights if you are using some brand name or you are using some patents whatsoever, so you need to limit that. And then if there is some dispute which arises at the later stage of at the time of the execution of the agreement, you need to write a dispute resolution clause and arbitration, like how you are going to resolve this issue. Then there are different boilerplate clauses. These could be called as the miscellaneous clauses, which includes the severability, force majeure, notices, assignment, amendment. By severability, it means that if one clause is found invalid, the rest of the contract remains in effect. Force majeure, if like something has happened, like in the case of the war, in case of some flood or something like that happened, which is not in control of a company, in control of the parties, then in such case, you need to write the force majeure clause. And for that reason, you need to write the force majeure clause. Then how the notices are to be served, whether these liabilities and responsibilities can be assigned to someone else or not. And if there is any need of the amendment into the contract, what would be the possible procedure for that? So these are basically all the main clauses of any agreement. You will find these clauses in any of a good agreement drafted. But obviously the wording of it, like how you are gonna cover the risk associated with these clauses, this you need to make sure to be provided with the proper legal advice. I hope that you will consider these points whenever you next time write an agreement.